Today's video will be focused on criminal law, and we will be taking a look at the topics we see students struggling with most often. Here to provide his expertise is AdaptiBar video lecturer and MBE expert, Jonathan Grossman.
Thanks, Jacob. Great to be with you guys to talk about crim law and crim pro a little bit, talk a little bit about approach, and for those of you that are dying to be DAs and PDs, we'll keep you in your place over there. For those of you that never want to see the inside of a courtroom, that's okay. Neither do I. I've 30 years, I'm successful without doing that. So we're going to talk about how to stop being a district attorney and public defender. But if you don't want to, how to get these questions right, not overthink, and we'll have some fun.
Awesome. And let's get started.
So crim law and procedure, although it is considered one topic, as you guys know, it's really two individual topics. So one tip I have is make sure when you're reviewing, you do one at a time. Focus on your crimes, criminal law, as a little mini topic by itself, because a lot of times people go from page 48, 49, 50, 50, they go into the other outline. And so if everything, again, kind of blends together, and I'm all about keeping everything separate. So first thing is separate crim law from crim pro, do one at a time, and then do the other. For criminal law, what does everybody screw up? Easy things like murder and manslaughter, right? There's that stupid phrase out there that the professor wasted 6 months of our life about malice aforethought. None of you know what that means. I know I don't. The professor doesn't even know what it means. He tried, but they're not successful because nobody really understands. They're not testing you on that on the MBE. They're testing you on definitions. The 4 kinds of murder and the 2 types of manslaughter. That's what you want to focus on. The rule, the elements, which murder, which manslaughter. Focus on your issue spotting. Most of the time, they're literally going to say, if charged with murder, is John guilty? If charged with manslaughter, is John guilty? Well, now I know what crime you're testing me on. The one big advantage in crim law questions, compared to a lot of other questions, is in crim law, it's one of those subjects where they literally give you the name of the crime, not always, but a lot of the time in the question. And everyone's thrilled. Oh, you see, it's a larceny question, John. I know that. It's a burglary question. I know that. Okay. But now, even though they give you the name of the crime, you don't know whether I'm guilty or not. And there's 2 answers that say guilty and 2 that say not guilty. So many of my DA/PD friends out there that like to litigate these things over here, if charged with burglary, will John be guilty? A, yes, he's guilty because he broke into the dwelling of another. That sounds good. You're too focused on those definitions. You think you know where the question is going. But what, again, is the common mistake of every bar taker? They didn't spend enough time in the facts. Facts. Just because you know it's burglary, larceny, or murder doesn't mean you know whether I'm guilty or not. How will you know if I'm guilty or not? The facts had to tell you. Slow down, focus on the facts, then you know which specific answer you are looking for. They will give you more help in the call, but just because you know the name of the crime doesn't mean you know if the elements were met. The inchoate crimes, the trickiest of all. Why? Because a lot of people do know attempt, conspiracy, and solicitation law, but how do they test it on the MBE? They make the whole hypo look like it's going to be a murder question. And then way at the bottom, it says, if charged with attempted murder, will John be guilty? And everyone is going so fast because you want to get to the answers, you don't even see the word attempt. But once they put the word attempted murder, conspiracy to commit murder, solicitation to commit murder, once they give you the name of one of those inchoate crimes, then the whole question is about the elements of an attempt, not about the murder, because attempt, conspiracy, and solicitation have their own definitions. So many of you say, I know attempt, John. Why am I missing all the attempt questions? Because you didn't recognize they were testing you on an attempt. The question usually doesn't say it's charged with attempt, is John guilty? It says, if John is charged with attempted burglary, is John guilty? Once they put that inchoate word in front of the crime, it makes the whole question about that inchoate crime, the attempt, the conspiracy, and solicitation. And once I know the question is about an attempt, my answer needs to be about the attempt. You with me? Many of you are picking answers about the elements of the burglary, robbery, and larceny, and I'm saying for the inchoate crimes, attempt, conspiracy, solicitation, even though they make the whole hypo look about one thing, now they're usually sneaking in the name of the inchoate crime at the bottom, and if you read 5 seconds too quickly, you miss it. Make sure that you not only know the rules for the inchoate crimes, but you make sure that you're answering the question based on the fact that they're asking you about one of those inchoate crimes. The rest of the crimes are fairly, as you know, self-explanatory with the definitions, but they're giving you tons of answers that quote the rules. Many of you overpick the legalese in the answers, not what the hypo is talking about. For example, with larceny, I always end up with your watch, but that doesn't mean I'm guilty of larceny. So if you read a little too quick and you say John took Jacob's watch and is looking at it, if charged with larceny is John guilty, and you pick up the word larceny and you peek at the answer choices too quickly, there's always an answer, yes, because John took the trespassory possession of the property of another, one of those legalese answer choices. And a lot of people pick it because it sounds good and it's the correct definition. But the answer usually is not guilty, because John just wanted to borrow the watch. John just wanted to check the time. You miss those key words in the facts because you're reading too quick, because it's nice and attractive that they give you the name of the crime. It's like a bait and switch. They're giving you the name of the crime in the call, so you're not even paying attention what the hypo looks like. Slow down, issue spotting, make sure you know whether I am guilty or not before you presume you know where you're at. Crim Pro. The big three items in Crim Pro are search and seizure, Miranda, double jeopardy. If you got those, you've got the core, not all, but the core of the Crim Pro portion of the questions. These questions are trying to get in your head. My classic example again, that's why I say to my DAPD people, don't litigate these things. Focus on the rule. For search and seizure questions, some of you love to talk about the 85 exceptions there are to warrantless searches. But what do I always say on all the questions? Only apply the rule. You only apply a defense or an exception if that's what the hypo is specifically testing you on. So when I go in, when the cop comes into John's house, there's always cocaine in my house. There's always dead kids in the trunk of my car. The cop's always going to find stuff, but that doesn't mean the cop did a proper search. You guys out there, some of you, like to always pick the answer about the exigent circumstances or the consent. You're looking for the exceptions. And I'm telling you, they're testing you on the rules, the black letter law. No warrant, the invalid search. How will I know when they are testing me on exigent circumstances or consent? Because that's what the facts will be talking about. You apply the exceptions or the defenses when that's what the hypo is talking about. Similar with the rest of Crim Pro. I always confess to something, but that doesn't mean that I was afforded my Miranda warnings. In Crim Pro, don't focus on the result, focus on the rule. Did the cop follow the right procedure, and what are they testing you on in Crim Pro? Just the definitions, no cases. So again, if you're a DAPD person, don't over litigate and think you'd make a certain objection. Just focus on the basic law and what that fact pattern said. You're on the transactional track and hate this stuff. Just focus on the bare bone elemental rules, and you focus only on what the facts say. And you presume they're testing me on the general rule, and I'm only going for an exception or a defense if that's specifically what the hypo is talking about. Separate Crim Law and Crim Pro. Focus on your black letter. Focus on your approach. Make sure you're picking the most specific answer to what the facts are talking about. And even if you never plan to be in a courtroom, you'll be shocked how well you can do in Crim Law and Procedure.
Great advice as always, and thank you again for joining us, Jonathan. To learn more from Jonathan on this subject, you can check out the AdaptiBar video lecture series, where you can also learn about any MBE subject available there as well. Thank you again for watching, and I'll hand it back to John to sign off for us.
No litigation, black letter law, reading comp and issue spotting. Presume they're testing you on the general rule. No exceptions or defenses, DAPD people. You focus on the rule and only pick the defense and exception when that's what they're talking about, and you'll know it because you'll shut up and pick it. Best of luck in Crim Law and Procedure.